This video is the third video in a series of 3 videos developed by the Arizona Center for Disability Law, or ACDL, through a grant from the Arizona Commission for the Deaf and Hard of Hearing, ACDHH, to address the issues facing people who are deaf and whose first and primary language is ASL. The first video provides basics about the right to effective communication in healthcare settings. The second video addresses frequent questions about whether video remote interpreting or an on-site interpreter is necessary to provide effective communication between the healthcare provider and the patient. The third video outlines the complaint options for when a healthcare provider discriminates and refuses to provide effective communication during a healthcare encounter. These videos are made available by ACDL and its legal staff for educational purposes to give you general information about the right to effective communication under the Americans with Disability Act, ADA, the Affordable Care Act, ACA, and the Arizonans with Disabilities Act, AZDA. The information in these videos should not be used as a substitute for competent legal advice from a licensed professional attorney in your state. By viewing these videos, you do not have an attorney-client relationship with ACDL. The actors in the video are not attorneys. I need a sign language interpreter for the future healthcare appointment and a related hospitalization. What should I do? Individuals who need an auxiliary aid or services, such as an on-site interpreter or video remote interpreting, VRI, should make the request in writing. The ADA, ACA, and AZDA do not require that the request be made in writing, but having a written request makes it easier to prove you did ask for an interpreter. The letter should state that a qualified interpreter is necessary for effective communication, why a sign language interpreter is needed, the date and purpose of the healthcare visit, and the name of the patient or companion making the request. Individuals may wish to refer to the law that requires healthcare providers to provide effective communication. Individuals should ask for written confirmation that the healthcare provider will be arranging for the requested interpreter or service. Here is a sample letter that individuals may modify to make their request and provide information about their circumstances. I requested a sign language interpreter for a future healthcare appointment, and the office refused to provide an interpreter. What should I do? Individuals who need an auxiliary aid or services, such as an on-site interpreter or video remote interpreting, VRI, should confirm in writing that the healthcare office refused to provide an interpreter. The ADA, ACA, and AZDA do not require that the refusal to provide an interpreter be in writing, but it would make it easier to provide the healthcare provider knew about the need for an interpreter in advance of the appointment and refused to provide one. The letters should identify the auxiliary aids and service requested, why it is needed, the date, the purpose of the healthcare visit, the date of the request, the date of the healthcare provider denied the request, and the name of the patient or companion making the request. Individuals may wish to refer to the laws that require healthcare providers to provide effective communication. Here is a sample letter that individuals may use to confirm that the healthcare office is refusing to provide a requested auxiliary aid or service, such as an ASL interpreter. If the healthcare provider does not provide what I need for effective communication, are there complaint options? Yes. Individuals can file a complaint with any or all the following agencies. First, complaints may be filed under the Americans with Disability Act, ADA, with the U.S. Department of Justice, ADA, Section DOJ. DOJ is the federal agency that is responsible for enforcing effective communication provisions for healthcare facilities operated by the state, county, city, or other local government agencies, such as Arizona Healthcare Cost Containment System, AHCCCS, and by private entities such as Banner. Second, complaints may be filed under the Affordable Care Act, ACA, with the U.S. Department of Health and Human Services, Office of Civil Rights, HHS. HHS is the federal agency in charge of enforcing the effective communication provisions under the ACA for programs or activities that HHS directly operates or which HHS provides federal financial assistance. Third, complaints may be filed with the Arizona Attorney's General Office, Civil Rights Division, under the Arizonans with Disability Act, AZDA. ACRD investigates complaints under the Arizonans with Disability Act, the AZDA. AZDA is like the ADA in that it also requires public accommodations to provide appropriate auxiliary aids and services to ensure effective communication. Fourth, individuals complaining about a healthcare provider that contracts with Arizona Healthcare Cost Containment Systems, AHCCCS, of the Arizona Long-Term Care Services, AHCCCS, may file an internal ADA grievance and a quality of care complaint. Does it cost any money to file a discrimination complaint with any of these agencies? No. It is free to file a discrimination complaint with DOJ, HHS, and ACRD. Is there a deadline for filing a discrimination complaint about a denial of a sign language interpreter with these three agencies? Yes, there are deadlines for filing a discrimination complaint with DOJ, HHS, ACRD for a denial of effective communication. The complaint must be filed within 180 days from the date an individual was denied effective communication. For example, if a patient who is deaf and whose first language is ASL was denied an ASL interpreter for a stay at a rehabilitation center on June 1st through June 8th, and the individual was denied an ASL interpreter for the entire duration of his stay, then the complaints would need to be filed with these agencies before November 28th. At this link, you will find an online date calculator. Do I need an attorney to file a discrimination complaint with these agencies? An individual is not required to retain an attorney before they can file a complaint with these agencies. However, an individual may be represented by an attorney if they wish and should obtain legal advice about the complaint process. How do I file a discrimination complaint with the DOJ under the ADA for the denial of effective communication? Individuals may file a complaint online, by mail, or email. DOJ has more information on its website. Use the link at the end of this video. Mail the completed complaint form to U.S. Department of Justice, 950 Pennsylvania Avenue, Northwest, Civil Rights Division, Disability Rights Section, Washington, D.C., 20530. Individuals should keep a copy of their complaint and the original documents for their own records. Fax the completed complaint form to 202-307-1197. How do I file with the HHS under the ACA for denial of effective communication? Individuals may file a discrimination complaint online, by mail, or by email. Here are some directions and links to help file the complaint. Online, use the link at the end of this video. For mail, mail the completed complaint and consent forms to Centralized Case Management Operations, U.S. Department of Health and Human Services, 200 Independence Avenue, Southwest, Room 509F, HHH Building, Washington, D.C. 20201. Email the completed complaint and consent forms to ocrcomplaints@hhs.gov. HHS cautions that communication by unencrypted email presents a risk that personally identifiable information may be intercepted by third parties. To protect information, use a popular email provider like Gmail or Yahoo when submitting information by email. After a complaint is filed, HHS will determine whether it has the legal authority to investigate the complaint. If HHS does, an investigator will be assigned. The investigator may start by interviewing witnesses, including the individual who filed the complaint, obtaining documentation, and making visits to appropriate sites. An investigation may take months to complete. After an investigation with HHS will issue a letter presenting its decisions on whether the ACA was violated. If HHS determines the ACA was violated, HHS will issue a corrective action plan. If the healthcare provider is willing to take corrective action, HHS may recommend initiating enforcement proceedings. How do I file a complaint with the ACRD under the Arizonans with Disability Act for effective communication? Begin by submitting an online civil rights questionnaire or call ACRD to request an intake appointment. Initiate a discrimination complaint by completing an online discrimination complaint form. Use the link at the end of this video. Mail, Arizona Attorneys General Office, Civil Rights Division, Phoenix Office, 2005 North Central Avenue, Phoenix, Arizona, 85004, 2926. Phone 602-542-5263. Fax 602-542-8885. Arizona Attorney General's Office, Civil Rights Division, Tucson Office, 400 West Congress, South Building, Suite 315, Tucson, Arizona, 85701-1367. Phone 520-628-6504. Fax 520-628-6765. call and request an intake appointment. Once ACRD receives a call requesting an intake appointment or receives an online civil rights questionnaire, they will schedule an appointment to do an intake. Afterwards, they will mail a complaint for the complaining party to sign, which might require a notary. Here are some helpful tips for filing complaints. Have the following information available: name and location of the healthcare facility, date of the request, date the request was denied, and details about the situation. Gather as much information to strengthen the claim. Provide a list of witnesses if there are any. Use descriptive statements about what happened. The more details, the better. Provide any written documentation, correspondence. For example, an email from a provider that states he will not provide an interpreter, or any other helpful written materials. What can I expect after I file a discrimination complaint under AZDA? After a discrimination complaint is filed under AZDA, the ACRD will provide a copy of the complaint to the healthcare facility. The individual filing the complaint is the complainant. The healthcare facility identified in the discrimination complaint is the respondent. In most cases, the ACRD will ask the complainant and the respondent if they would like to use voluntary mediation to try and reach an agreement before the investigation begins. If one or more of the parties does not agree to mediation, the ACRD will ask the respondent to provide a position statement. This is the first step of the investigation. A position statement is prepared by the respondent and provides a written response to the statements in the discrimination complaint, as well as any reasons why the respondent did not provide the sign language interpreter. After the position statement is reviewed, the ACRD will interview the complainant about their complaint and information in the respondent's position statement. This is called the position statement review. After the position statement review, the ACRD will decide what additional investigation, if any, to do before reaching a determination about whether discrimination occurred. What is mediation, and what happens if I choose to try mediation? After a discrimination complaint is filed with ACRD, mediation may be requested. The healthcare office or hospital must agree to mediation too. Mediation is an informal, confidential process where a trained, impartial person, the mediator, facilitates discussions between both parties to help them clarify issues and negotiate an agreement. The mediator does not act as a judge and will not make a decision. The information obtained during mediation is confidential and cannot be used as evidence elsewhere, such as a trial, unless the information is learned from somewhere else. Mediation is an opportunity for both sides to get creative towards finding a resolution to the legal issues. Participants can ask for the types of relief that are generally available under AZDA, which includes an agreement to provide the appropriate auxiliary aids and services, monetary damages, attorney's fees, and other relief. People often seek an agreement to provide an interpreter for future healthcare visits, development or improvement of an effective communication policy, posting the policy where patients can find it, such as on a patient portal, staff training about the law, deaf culture and language, and an amount of money to compensate the denial of effective communication. But participants can be creative and ask for additional corrective action. Monetary damages are available. An individual may be represented by an attorney at mediation, although one is not required to participate. Are there any advantages to try mediation? Yes, there are many good reasons to try mediation. Mediation allows the parties to develop their own solutions to ADA disputes. Mediation can offer a quick and satisfactory resolution of a dispute and can be far less expensive and time-consuming than a formal investigation or going to court. Mediation may mend relationships between parties. Parties do not lose any rights in attempting mediation. And mediation is confidential and voluntary. A successful mediation results in an agreement signed by both parties. This means that if the respondent does not follow through on the promises it made in the mediation agreement, the ACRD or the complainant can ask a state court to enforce the agreement. If the complainant and respondent do not reach an agreement, then the complainant will be returned to the investigator to proceed with the investigation. If mediation is not helpful, how can I prepare for the position statement review? Request a copy of the position statement and ask to look at any documents the respondent attached to its position statement. Individuals must sign a non-disclosure form indicating the information disclosed will not be made public or used except during the complaint process itself. Read it and understand what reasons they are giving for not providing an interpreter. Be prepared to address each of the healthcare provider's reasons for not providing effective communication. Request a sign language interpreter for the position statement review with the Attorney General's Office for the position statement review. Under state law, the Attorney General must use an ASL Legal A interpreter for the position statement review. Verify the Attorney General has made those arrangements. The agency must provide interpreter or other accommodations for free. After both sides have submitted the materials requested by the agency, the investigator will contact the complainant to set up a position statement review. The position statement review is an opportunity to go over the discrimination complaint, point by point, and to go over respondent's position statement, point by point. During this process, the investigator may ask follow-up questions. For complainants, do not need to wait for a question. For example, if the investigator is going through the respondent's position statement and the complainant disagrees with the statements, they may ask the investigator to pause and provide an explanation of why the statement is incorrect. The investigator may ask additional questions as well. Once the position statement review is complete, the investigator will continue with their investigation. If I receive services through the Arizona Healthcare Cost Containment System, AHCCCS, and I want to file a grievance because my healthcare provider refused to provide an interpreter, how can I file a grievance? An individual who has a problem with healthcare provider can file a complaint with AHCCCS online, by email, or by phone. The individual should have their AHCCCS identification number, date of birth, phone number, and the number of the provider available. The individual should also be prepared to provide a short description of the issues they faced with the provider. Online, please see the link at the end of the video. By email, you can email cqm@ahccccs.org. AHCCCS.gov. By phone, you can call and report your complaint to 602-417-4885. May I file a lawsuit if a healthcare facility fails to provide effective communication? Yes. Individuals who believe that they have been denied effective communication by a healthcare provider may file a lawsuit in federal or state court under the ADA, the ACA, and AZDA. Before filing a lawsuit, individuals should consult with an attorney to obtain legal advice and, if possible, legal representation. What is the deadline for filing a lawsuit? The deadline for bringing a lawsuit under these laws is 2 years from the date of the alleged discrimination to file a lawsuit. Individuals should consult with an attorney about the specific deadline because there may be reasons why they have a longer period, such as the discrimination occurring to a child. Do I have to first file a complaint with DOJ, HHS, or ACRD before I can file a lawsuit? No, an individual may file a lawsuit without first filing a complaint under the DOJ. An individual may go directly to court under the Rehabilitation Act without first filing a complaint with the HHS. An individual may also file a lawsuit under AZDA without first filing with the ACRD. What kind of relief can a court award if I win the lawsuit? If successful, an individual who wins a lawsuit under Title III of the ADA may obtain an order requiring the healthcare provider to provide effective communication for healthcare encounters and reasonable attorney fees. In a case brought under the AZDA or Title II of the ADA, the individual may also obtain monetary damages. Monetary damages do not include punitive damages. Punitive damages are damages meant to punish the healthcare facility for the violation. Out-of-pocket expenses and emotional distress damages are available under AZDA and for actions against healthcare facilities operated by state or local government. We thank you for your time. As always, you can visit us on the web at www.AZDISABILITYLAW.org or call our office at 602-274-6287.